Calling case number 24055455501. The people of the state of Michigan versus Berncia Volkachuk. The defendant is charged with count 1, assault with intent to murder, count 2, unlawful imprisonment, count 3, assault with intent to do great bodily harm, less than murder or by strangulation, count 5, weapons, firearms discharged in or at a building causing injury, count 6, weapons, firearms, possession by felony, count 8, assault with assault with a dangerous weapon, felonious assault, counts 9 through 14, weapons, felony, firearms, habitual offender, second offense notice. This is the date and time set for bond redetermination. Appearances, please.
Good morning, Judge. Steve Vincent for the people.
Your Honor, may it please the court, Reagan on behalf of Ms. Bukovic.
Okay. What is her bond?
500,000 cash, GPS tether, house arrest.
Okay. Let's see. Have we done this case before?
Yes, Judge.
Yes. Okay. Why is it back?
Because it was dismissed, Judge. And then it got reissued again, Judge.
Oh. Okay. Argument.
You know, Judge, so it is reissued case was dismissed before. Ms. Bukovic is 29, Your Honor. She has a child that she lives with, she takes care of, Judge, in the Metro Detroit area. You know, she doesn't have any assaultive history. Now, you know, this case, Judge, obviously there's more to a lot of things than what you read. You know, I was reading some of the investigators' report, Judge. Talks about all these individuals, you know, in a certain area getting tied up, you know, and
Mute the jail, please. Thank you.
And guns being pulled. I don't know if that's me, Judge, with feedback or
No.
I just muted the jail.
okay. So, Judge, and you know, we talk about guns and all these individuals. So, you know, according to the report, it was at least 5 individuals, I guess, in that room. So it's alleged that my client, you know, shoots one person in the scrotum, and for some reason, that person is just able just to walk out the house after he gets shot. And then there have 2 other people that seem to be able to just walk out the house and not get shot. So, Judge, you know, when you're talking about the whole scenario of you know, tying people up, doing all this other stuff, trying to shoot people, you know, a lot of times, you know, generally, you know, people don't just walk out the house. I think it's a lot more to it, Judge, a lot more to it that's going to come out. But at this time, I understand that the bond is $500,000. Obviously, Judge, based on her lack of prior assaultive history, in fact, she has a daughter. You know, she has ties to the community. The fact this was dismissed once before, I don't know what's going to happen this time. I'm asking for a reduction, Judge, to a high, obviously a high personal bond with GPS tether.
Quick question, Mr. Reagan. Quick question.
Yeah,
what was the bond that I set last time?
I don't remember, Judge. I don't.
It was $1 million, Judge. You continued it.
Okay. Okay.
Yeah,
Okay.
I don't remember, Judge. But I just know that, you know, I read it and you know, it just obviously, you know, you read stuff and like, and it, you know, and it just doesn't make sense how people can just walk out the house after they get, I mean, you know, that, and that just makes no sense because I think it didn't happen exactly the way that the investigator's report reads, Judge. I think there was a lot more to this than what it says.
Argument, Mr. Prosecutor.
Judge, Mr. Reagan's right. There is a lot more to it than what he just ended up telling you. And, you know, with all due respect, the defendant has a child that she allegedly takes care of. She didn't put that child into account when she got into this situation. This situation has to do, Your Honor, just to refresh your recollection, has to do with a federal investigation for drugs that leads to this incident where the defendant and this co-defendant end up going to a residence. They end up confronting the complaining witness who allegedly was a snitch in that federal investigation for drugs. So what do? They go to that residence, they threaten that complaining witness. How do they threaten that complaining witness? First off, they end up brandishing a firearm and they put a bullet hole through the kitchen wall. Then they take the individual down to the basement. They put a plastic bag over one of the individual's heads. Then this defendant gets water in a bucket, apparently for some type of waterboarding or whatever that they were going to do with that. But we didn't even get to the bucket of water. Why? Because this defendant ended up shooting one of the complaining witnesses in his groin, in his scrotum.
Mr. Prosecutor, unfortunately, I remember every detail of this case, so I'm gonna kind of cut you off because I know you're making a record, but I'm very clear on this one. Court haven't heard I'm not sure why the matter was dismissed, but court haven't heard the arguments of counsel. Court finds that the $500,000 cash bond is an unaffordable bond. Court finds by clear and convincing evidence that the defendant is a danger to the community. And therefore, the $500,000 cash bond is an appropriate bond and will be continued.
Judge, can I just point out one thing that the report talks about? It talks about if there are witnesses, Judge. The co-defendant was armed with the gun. He instructed Ms. Vukovic to shoot or there would be consequences. And that's what one of the witnesses said that, who was present. And that's part of,
she's gonna have a duress defense that she can put as an affirmative defense at a later time in front of a trier of fact. That is the definition of doing something under duress. So
I want the court to understand and just mention that to the court.
Yes, sir. Yes, sir. Duly noted. Bond continues. Ma'am, you can go. Thank you. And who's the last person?
He's coming. He's in the weight room. He's coming in now.
All right.
Mr. Reagan, I do appreciate you mentioning that because this is the defendant.
Can I speak with Mr. Smith in the breakout room real quick?
Yeah.
Okay. Call the case, please.
Calling case number 240-554-5502. The people of the state of Michigan versus Donnie Lamont Smith. The defendant is charged with count 1, assault with intent to murder, count 2, unlawful imprisonment, count 3, assault with intent to do great bodily harm, less than murder or by strangulation.
You got to kick that.
Count 4, weapons, firearms, discharge in or at a building.
Yeah, but
Count 7, weapons, firearms, possession by felon. Count 8, assault with a dangerous weapon felonious assault. Count 15 through 20, weapons, felony, firearms, second offense.
It was a bad play call, but
Habitual offender, fourth offense notice. This is a day and time set for a boundary determination. Appearances, please.
Judge, pleasure and privilege. Steve Vincent for the people, 71917.
And Your Honor, taking on behalf of Mr. Donnie Smith. And Judge, Mr. Smith's been here all morning on camera. It's been working. We were just in the breakout room. So I don't know if somebody over at the jail can just like maybe turn it on. We were just talking a second ago and it was working fine.
Madam Clerk, call over to the jail, please.
Oh, yeah, I'm calling.
yeah,
Oh, he's on there. Oh, he on there.
they're going to slow walk the paperwork so that she's not discharged before 3 o'clock, so I can go.
Mr. Smith, state your name for the record.
Donnie Lamont Smith.
Okay. Argument.
Judge, I'm gonna keep it short and sweet. 44 does have priors. This is a reissue case, Judge. This case was just dismissed Friday. Complaining witnesses did not appear. I guess they waited over an hour and a half and it was dismissed. As Mr. Smith was being released, he was just rearrested. Didn't even have the warrant re-signed yet. and brought down to the Wayne County Jail. So we're back again. Again, Judge, you know, it's a case where bond is $500,000. We're asking for reduction, something more reasonable. I'm not going to sit here and ask for a personal bond, Judge, because I don't want to insult the court, but I'm asking for something more reasonable. Again, Judge, when you have to sit in jail and you wait for your case, and when it doesn't, people don't show, you know, it almost, you know, it affects your due process to a degree, because you have to sit again and again and again and again. I'm asking for reduction from Mr. Smith so that he can be allowed to at least have an opportunity to post something and get out, Judge, so he doesn't have to sit again and have this matter dismissed again and have to be rearrested again and have to sit again. So I'm asking the court to consider that, Judge.
Court having heard the arguments of counsel, court finds the $500,000 cash bond is an unaffordable bond. Court finds in order to have an unaffordable bond, there has to be a showing of danger to the community, to the complaining witnesses. Court finds based on these allegations in this case that the defendant possibly poses a threat to both the community and the complaining witnesses. Court is therefore going to continue the bond as set by the magistrate. Thank you very much.
Thank you, Judge.
All right, you guys have a good one.
Thank you.
And I will tell my Matlock story tomorrow. All right.
All right, looking forward to it.
All right.
Mr. Reagan, you can leave.
The Benson, you can go.